Welcome to Rebel Chaser. My name is Gail, and today I have just a group of kind of crazy clips. They're all fairly short, they're all very different, but I'll let you guys watch because I don't want to give it away.
Devin Heflin, come down.
Let me get this stage.
Hello.
Hello.
All right, so we've attempted to have you brought over to court twice, but they tell me you're disruptive. Let me tell you what ends up happening when people are disruptive. They'll bring you over for trial because there are certain parts of a trial that you need to be present for. Did you ever see the movie involving Hannibal Lecter? They will bring you over to trial, strapped down to a chair with a face mask on, and guess what? Your attorney will try to explain to the jury why you're strapped down with a face mask on. The jury will take it to mean whatever they will mean, and you'll be going to trial strapped down. Do you understand? So do not be causing issues when you're being brought over. Do not be trying to flood toilets. I always think when people flood toilets, I always think they should be required to clean it up because then they won't do it anymore. Somebody had to come and clean that up. So where are we?
It was actually our first setting today, Judge. I have downloaded the discovery. There's some videos I need to be looking at. They did give me an offer this morning. My client has declined the offer as of today. I'm going to review the video evidence, have another visit with him. And so at the next setting, we can look at that offer again.
All right, Ms. Ferguson, recall this in 3 weeks for a plea deadline date, please.
I can do the 20th.
All right, we're coming back on February 20th. On February 20th, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the offer, that's completely up to you. What will end up happening is your plea deadline date will be expired and you will be going to jury trial. And if after that point you decide to enter a plea, you'll have to plea open to the court because the court will not consider any plea bargain agreements without good cause. Do you understand?
Hold on. I only get one plea?
No, what will end up happening is on February 20th, my understanding the state has made an offer to you. People, sometimes they need time to think about offers. Sometimes people receive an offer and they want to make a counter offer. They want to say, I want to accept this offer, but if you offer me this, I'll accept that. So what I'm telling you is if there's any other negotiations regarding the plea bargain agreement that the state has offered, that needs to be done by the 20th. And on the 20th, you need to let the court know whatever agreement perhaps you all have come up with. On that date, you need to let me know whether or not you have an agreement, whether or not you're accepting a plea. If you say, I'm not accepting the plea, then what's going to end up happening is you're going to be put on the trial docket. And let's say trial is set and you see a jury coming in and you're like, shucks, I need to plea or I want to accept a plea. The state may have an offer available that they're offering to you, or they may say, nope, jury's here. We're going to trial. We're not making you any more offers. Or they may say, we're going to make you an offer. If they do, then I will only accept a plea bargain agreement without good cause. And what do I mean by that? I mean, you file paperwork saying, hey, I want you to consider this plea because now I changed my mind. I want to enter a plea. There needs to be a good reason for me to accept a plea when it could have been done on the 20th. Because once a jury comes up, the jury's been brought out, we're going to trial.
So basically it is only get one plea in trial?
No, you get a chance to say on the 20th.
Get one plea, then I get to offer a plea, then it's trial.
Yes, so what ends up happening on the 20th?
Why trial come so soon?
Because in this court, when people want a jury trial, they get a jury trial quickly. I don't have people staying at the jail. I don't let people stay at the jail for years, months, because I don't think that's the way it should be done. I think you're entitled to a quick trial, speedy trial, fair trial. The complainant is entitled to a quick trial, speedy trial, fair trial. People are not entitled to sit at the jail for 3 years or 2 years or 9 months waiting for a jury trial. So I'm working my way through all of the cases that were on my docket before I even became a judge. And people who want trials, they're being given trials. We just finished a trial yesterday And we are starting a trial this afternoon.
Devin, I'll talk to you
So.
on Zoom. Just,
All right.
we're getting a reset.
So that's what's happening.
It's just a baby question.
I'm sorry?
Devin, my advice to you is we'll talk on Zoom, okay?
All right. So you'll come back on the 20th. You
Thank
understand?
Judge. We'll have a visit before then.
All right. Thank you. And I'm sure you'll explain
I will.
everything.
How
Hold on a
about
second,
Ms.
sir.
Fulford? You able to hear me?
Yes.
All right, let me read this to you. This says that back on November 26th of last year on 10th Street there in Wayland Township, you had a driving while license suspended. You also had a ticket for expired plates. That ticket for expired plates is not punishable by jail time, but it is punishable by additional fines and costs. Do you understand both your things? Both your charges?
I don't understand. I submitted an affidavit of truth and fact to the court on 11/29/23. I then submitted a notice of default judgment of a rebutted affidavit on 1/3/23. I have all the receipts of proof, and I'm here to see if that matter is closed.
All right, so do you want to plead guilty or not guilty to your misdemeanor charge?
Not guilty.
All right, and if that goes all the way to trial, would you like that trial to be in front of a jury or in front of a judge?
Shouldn't go to trial, it's unrebutted.
From my understanding, it shouldn't go to trial. It's unrebutted. I haven't heard back from my affidavit
Yeah,
yet.
ma'am, we don't deal with all that UCC stuff. You can say all of it, but this is a court of law, and we go by those rules. You can enter a plea of guilty or enter a plea of not guilty. What would you like to do? You said not guilty. I'm writing you down for a jury trial. You can continue to represent yourself for free, or you could hire an attorney. I'll give you a $300 PR bond. Personal recognizance, please don't drive without the valid driver's license till those dates. Is this a good address for you on 4th Street?
Yes.
All right, so you will get a next court date sent out to you on that, at that address on 4th Street. That'll be the next time you're due in court. First time you get to talk to someone from the prosecutor's office, hopefully resolve your matter, but you are all set for today. You can go ahead and go.
Ms. Gardia?
Is she there?
Yes, there's a Samsung here, but there's no response.
She said she's in the waiting room.
Oh, no, I brought her into the main room and she's not responding. She's connecting.
She said she went to the office at her apartment to get some help, so I think somebody's helped her.
Okay.
Hello, can you hear?
Hello?
Hello?
Yes, I can hear you.
All right, are you Miss Gardia?
Yes, I'm Miss.
All right, is there a
Yeah.
reason you're not in court today?
I'm very ill.
All right, what is your issue?
I don't know how to pinpoint all of them, but I'm having a problem living.
Okay.
My health is deteriorating.
All right, Miss Gardia,
Yes.
I'm going to need you to come to court tomorrow, okay?
I can't make it there. I cannot.
All right. If you don't have a doctor's excuse or something from your attorney that you're in the hospital,
Send
you're
me
going to have to come to
a
court.
mental hospital. This is to keep me what do you call it? Every time I do that, something bad happens to me.
Every time you come to court?
No, every time I go to the hospital, I can't, or do I have to go to a doctor or go to the hospital? And then they'll send me to a mental hospital, and I'm in the hospital for a long time. And then I come home and my place is wrecked.
Okay.
Okay, and now there's some stuff going on, and there is exploitation going on, identity theft and DNA through DNA. harvesting DNA for identity theft purposes with Haven for Hope, and et cetera, et cetera, et cetera. And I am a victim for almost 20 years. This is my issue, and I got abducted through them following me and falsely accusing me of this, what was going on. I am not a mental schizophrenic, paranoid, all the other things that they're saying. That's how they did it, through the internet. This is my situation.
All right.
So
I understand.
If I do that, this whole thing is going to go, and I am going to have a heart attack because I'm not well.
All right. I understand, Ms. Gardia, but I'm going to need you to come to court tomorrow. And then what will happen when you show up to court tomorrow, your attorney will be here and your attorney will speak to you, because I need you to come in so that your attorney can speak to you in court and so that your attorney can review your case in court. All right. Is there anything else? All right. Thank you, Ms. Gardia. And thank you to the person who helped her Zoom in.
Good morning, everyone. We're here for first appearances. Corporal Jones, sir. Good morning. Have you had a chance to play the first appearance video?
Good morning. Yes, sir, I have.
Great. Thank you. Ladies and gentlemen, I'm Wade Mercer, County Judge in Jackson County. On your screen, you're going to see one of the two attorneys involved in the first appearance process. The first attorney is Mr. John McDaniel, Assistant Public Defender. He's already at the jail. Spoken to those of you scheduled for first appearances. In the courtroom, we have the other attorney, Ms. Bremer. I'm going to ask that she introduce herself.
Kara Bremer on behalf of the state.
Thank you. Can you see and hear both of us at the courthouse, Corporal?
Yes, sir, we can.
Great. First case is Fanette Brown. Ms. Brown, good morning. Ms. Brown, you're here for first appearance accused of one count of breach of the peace. Ms. Brown, there is probable cause for the charges, ma'am. I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Pardon me. It wasn't a such thing as breach of peace.
Did you see the text message?
Or what is it? You're saying breach of peace? They said trespassing and I need to trespass on my daughter? No, because that's not her driver's license. That's my other daughter that's in that residential area. So when I went to go check on my clothes and check on her to make sure she was all right, and since she had to work that day, I knocked on the door. I said, Deborah, I said, you don't have to open the door. I said, look at me, baby, let me see you, because I was called from Louisville, Kentucky. And they told me I had a child abduction that I had to get on the Greyhound.
Ms. Brown, I'm not going to try to talk over you. You're going to have to be quiet and listen to me, or we're going to be through with this first appearance really quick.
Are you the same one that you?
The complaint,
is that
your
Mr.
bond's $2,500 cash or surety. That's your bond. Have a good day.
What did you say?
Judge, can we get a evaluation done? Yeah, we get life management doing evaluation,
that's the same
please.
one that sent me to life management. So y'all planning vacant offices or something?
Corporal, we need to get her out of there. I'm through with the first appearance. She's got a bond. She needs to go.
Before we go through this?
Yes, sir.
I'm not getting in my ass. Y'all follow Ligarian now. There's some consequences need to be done about this. No, you're not. Stop chasing me for money about.
Apologize, I try to send these text messages to y'all when I don't know. If there's a better option, let me know. I don't know. I think you get them riled up before we get on court. That's what happens, ain't it? I apologize, Your Honor.
This one wasn't his fault.
Ain't nothing you can do about it. I think she may have some issues, but we'll see what life management says.
All right, we're here on two files, 2313221 FH and 2313210 FH. This is the people of the state of Michigan versus Eric Lee Van Zant. We're here for defendant's counsel's motion to withdraw as counsel. Court received that yesterday by email. Mr. Van Zant, did you get a copy of that at all?
I haven't got anything from that lawyer, Your Honor. He hasn't done anything for me or shown me any videos on the chest camera.
Sir, I didn't ask you about that. I just asked you if you got the motion.
No, I haven't got anything.
Basically, it says that that you don't think he has your best interest in mind, won't file motions that you want, even though he thinks that his opinion is that they don't have any merit. Just essentially that there's been a breakdown in the attorney-client relationship, that he doesn't think that he's the best guy for you. Do you agree with that assessment?
I told him that, he wasn't the best guy for me because he needed somebody to hold onto his hand because he couldn't do his job.
So the court is going to grant the motion for Mr. Niegos to withdraw his counsel. And so, Mr. Van Zant, we're in a situation where Mr. Niegos was the third court-appointed attorney. I'm going to give you really one more chance. After that, you will have forfeited your right to be represented by indigent counsel.
I got enough money. I bought my own.
You did. Who'd you hire, sir?
He'll let you know. He knows already.
Oh, okay, good.
Matter of fact, he should have told you already.
All right, so at this point, we won't appoint you another counsel. You've indicated that you've hired your own counsel. We haven't received any appearance from that individual, but I guess we will shortly. So
You won't.
I guess the next thing that we need to do. Let's see. Probably should schedule something before the March 19th jury trial. So we have a date, next couple of weeks that we can get with Mr. Van Zant's new counsel.
February 6th of 11.
Okay, February 6th at 11 o'clock. And if you're in communication with that individual, you can let them know. As soon as they file an appearance with the court, we'll let them know as well.
Yeah, I would imagine as long as this guy can do his job and make sure he gets all the paperwork that he needs, it would be a good schedule. But if he can't get the paperwork that he needs and everything that I need from him and the other lawyers that I've asked for several times, we're probably gonna have to schedule that again.
Reschedule the trial?
Oh, I'm sure.
Okay. All right,
Because
well,
you got, nobody can do their job here.
all right.
I've asked you several times to give me 3 counsels and I ain't getting nowhere. I've been here 9 months.
So we'll deal with that request if the new attorney makes it. So that's all for today.
Hello.
How are you?
All right. How are you doing?
Good.
So have you filled out your application for the PTD?
What is that?
Step up a little bit.
Did your attorney not speak to you about the pretrial diversion?
Yeah, I told him I didn't want to take any type of probation or anything due to my veteran status. And me and my parents have already, my mother actually wrote a letter to give to the court. My father already went down to the office to drop the charges. So I'm not understanding why I have to take a plea for this case.
Oh, you don't have to take a plea. But your attorney will speak to you about people dropping charges. Because some cases, the complainant can say they don't want to go forward, but this is not the complainant's case. It's the state of Texas versus.
Right.
And the reason why it says the state of Texas versus, whenever you have alleged crimes that have been committed, the crime is against the state of Texas.
Okay.
So, Ms. Ferguson.
Yes, ma'am.
She doesn't want PTD. So give me a jury trial setting, please.
Okay.
So if I take it to trial, that means I get a longer sentence or something, right?
You'll have to speak to your attorney. What I can tell you about jury trials is what ends up happening is your attorney is present, the state is present. There's something called jury selection because this is a felony. 12 people will sit in the box
Yes, ma'am.
and the state will present their case through witness testimony or whatever evidence they have. And then you and your attorney can present evidence if you choose to. You don't have to because the burden is on the state. And then the jury will deliberate after closing arguments and they will make a decision on whether you're guilty or not guilty. If they say that you're guilty, this is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. And depending, I don't know your case. All I know is the charges. So you may be eligible for probation from a jury. All right,
Well,
Ms.
I'm already a felon. Is there any way we can postpone this, like reset my court date? Because I don't
She's
really
giving you-
talk to my,
She's giving you a trial date now. What's the date?
February 12th.
All right, your jury trial date is going to be set for February 12th. Once you sign the reset form, you're excused and you'll need to be here at 9 a.m. for jury trial.
Judge, I'm sending her the impact.
All right.
on that day.
December.
All right, so Ms. Shepherd, you'll be meeting in impact court instead of here for your jury trial.
Sometimes I find these short clips that I can't really put out on their own because they're just not long enough. So I put them all together. I hope you guys don't mind. Thank you so very much for watching, and I'll see you next time.